In this short video, I will explain when cancellation of the charter party may be allowed, when damages or compensations are the only remedy when vessel is delivered not as described. I'm Captain Mohamed Bazina, Managing Director of Bazina Shipping for ship chartering training and consultancy. Topics we'll discuss today: when misdescription of the ship may justify a charterer to cancel the charter party. Also, we need to know the contractual terms like condition, what do we mean by condition, warranty, and innominate or intermediate terms. And we will end up at the end of this video by recommendations how to avoid dispute and safeguard your commercial interest. Consequences of misinterpreting charter party contractual terms. Many ship owners and charterers end up in costly disputes simply because contractual terms were misunderstood or misinterpreted. The disputes can cost significant money and damage creditability. So in this video, we will clarify key contractual terms to help you avoid unnecessary financial risks. When misdescription justifies cancellation, or when the charterer can cancel the charter party if it is required or necessary. If the misdescription or the ship delivered not as described, the misdescription is so serious that it goes to the foundation or the root of the contract and prevents the charterer from receiving the intended benefit of the contract. Example, ship is not suitable to load the agreed cargo. Of course, the charterer will be able to cancel the charter party. Usually. Also, more grounds for cancellation. The owner refused or failed to take reasonable steps to make the vessel comply with the contractual description. Also, failure to meet cancelling date requirement, like the misdescription, is such that the owner is unable by the cancelling date to meet the contractual requirement under the cancellation clause. Now we need to know more about contractual terms. What do we mean by condition, warranty, and an innominate term? There are three classes of contractual terms. A condition, the breach of which will always entitle the innocent party, or we mean here the charterer, usually to bring the contract to an end. If it was a condition and it's been violated in the charter party, we have something else, we call it a warranty. So the breach of which will never entitle the charterer or the innocent party to bring the contract to an end. We will go in more details shortly. Also, an innominate term or intermediate term. A breach may allow the innocent party to terminate the contract only if the breach is serious enough to go to the root of the contract. We will explain shortly what do we mean by that. So the charterer may only terminate if the owner breaches a condition of the contract which is clearly explicit or implied by law, or an innominate intermediate term in such a way as to go to the root of the contract. What do you mean by a condition here? A condition is an essential term of the charter party. If it is breached, the other party may cancel the charter or terminate the contract. Some conditions are implied by law, like seaworthiness. Other conditions are clearly and expressly stated in the charter party, such as the cancelling date. Example, as an express or stated in the contract condition, like for example, the cancelling date clause in all forms of charter parties. Charter party normally give charterer an express right to cancel the charter if the vessel arrives late or not ready to load by the cancelling date. Here as an example in form NYPE 2015 clause number 3, lay days cancelling. Of course, if the vessel is not ready by the cancelling day, so the charterer can or may cancel the charter party or as agreed in the charter party. Other example of conditions like the name of the ship. Of course, we have to agree on the name of the ship, but in some cases, the charterer and the owner, they can agree or they may agree on a substitution. So it depends on the charter party. Conditions, also we have some examples like seaworthiness. As a condition, seaworthiness means the ship and equipment are fit for the voyage and cargo safety. That's including cargo worthiness. The ship can safely carry the agreed cargo to its agreed destination. Let's discuss warranty. What do you mean by warranty here? A warranty is term of the charter of less importance, like a breach of warranty will not give rise to the right to terminate the contract. So the innocent party or usually the charterer may claim only damage or compensation. Example like discrepancies in fuel consumption and speed, which is very common. Speed normally is a warranty but may be treated as a condition for liner shipping or maybe ferry boats or cruise ships. Let's discuss here intermediate term, like in between. It could be treated as a condition or it could be treated as a warranty. So it depends on the situation here. So it could be treated as a condition or warranty. For intermediate terms, the right to terminate depends on how serious the breach is and its effect. Termination is allowed only if the breach deprives the charterer of the main benefit of the contract. So let's discuss more examples to clarify this point. Like, for example, changing the flag of the ship. Usually, changing the flag of the ship doesn't make any problem for the charterer, usually, but sometimes it could be a problem, like in war time, for example, or the ship is not allowed to enter specific ports with the new flag. The charterer in this situation can cancel the charter party. Regarding intermediate term, also like speed and fuel consumption, of course, if usually speed and fuel consumption usually they are treated as a warranty, it will not give the charterer the right to cancel the charter party usually. But in liner shipping or cruise ships, for example, it could be treated as a condition. What charterer's remedy here for misdescription? The charterer here, if the misdescription is discovered after delivery, like speed consumption or consumption issues found during service, charterer can claim damages or compensation for the breach of the charter party, and in certain cases he can terminate the charter party. This depends on whether the terms as to description was a condition, an intermediate or innominate term, or a warranty. Recommendations to avoid disputes: to safeguard your commercial interest by negotiating the charter party carefully. Ensure any critical terms are clearly stated as conditions if needed. Always read the charter party carefully, especially before making any cancellation decision. Seek legal advice and consultancy before canceling a charter party to avoid the consequences of wrongful cancellation. Thank you for watching. For professional ship chartering training consultancy, you can visit our website for the upcoming courses and enrollment.